Today, we are diving deep into a really crucial and, let's be honest, often misunderstood area of the law, Rule 101 of the Philippine Rules of Court. This is all about the hospitalization of individuals who are believed to be mentally incapacitated. Welcome to LexAI, your AI-powered partner in mastering the law. We combine artificial intelligence, legal analysis, and jurisprudential insight to make complex legal doctrines clear, visual, and easy to understand. So this whole topic really boils down to one very delicate question, doesn't it? How does the law manage to protect society while also protecting an individual's fundamental liberty, especially when mental health requires some kind of serious intervention? Well, Rule 101 is a legal framework designed to do exactly that. Here's our game plan for this explainer. First, we'll do a quick introduction to Rule 101 itself. Then we'll walk through the whole process, starting with the petition. After that, we'll look at the hearing and judgment, cover how discharge works, and finally, we'll wrap it all up with a summary of the core principles you need to know.
All right, let's dive right in. First up, an introduction to Rule 101. We need to understand what it's all about, its scope, its purpose, and why it's such a serious matter.
So, what is Rule 1001 at its very core? Well, you can think of it as the official legal playbook for when a person might need to be hospitalized for mental health reasons, even if they don't want to be. Its main job is this critical balancing act. On one hand, it has to protect public safety, but on the other, it has to fiercely guard an individual's right to liberty. And it does that by making sure due process is followed every single step of the way.
So, how does a process this serious even get started? Well, it doesn't just happen. It all kicks off with a formal, legal document called a petition. Let's look at Section 1.
And before we get into the weeds, here's a quick, high-level look at the entire process. It's a pretty clear four-step journey. It starts with filing the petition, then the court orders a hearing, the hearing and judgment happen, and then finally, there's a process for discharge. We're going to start at the very beginning with Step 1. Now, the law is super precise about this. The petition can't be filed just anywhere. It has to be in the regional trial court of the province where the person is physically located. And it's not like just anyone can file it. That power belongs specifically to the Secretary of Health. The reason? It has to be for the public welfare or for the welfare of the person themselves. But here's the absolute kicker. This is a last resort. The court only gets involved if the person or their guardian is actually opposing voluntary hospitalization. Okay, time for a little pop quiz. Let's see how this would look in a bar exam. Who is allowed to file this kind of petition? And where exactly should it be filed? Take a second to think about what we just covered. And the answer is the Secretary of Health, remember it used to be the Director of Health, is the one who files the petition, and they file it with the regional trial court of the province where the person is found. It's simple, direct, and straight out of Section 1. Okay, so once that petition is filed, we move into what is arguably the most important phase of this whole thing, the hearing and judgment. This is where the court really steps in to ensure everything is fair and to make a final decision, all guided by Sections 2 and 3. Because we are talking about potentially taking away someone's liberty, the law puts up some really strong safeguards. First, the court has to make sure the petition itself is legit. Then it has to issue a formal order of hearing. And this part is crucial. Everyone involved has to be notified, the person, whoever is taking care of them, and their family. And finally, if at all possible, the person needs to be present in court so the judge can actually see and observe them directly. Now, this whole process is a perfect example of a legal doctrine called parens patriae. It's a Latin term that literally means parent of the nation. What it means is that the state has a fundamental duty to act as a guardian for people who can't take care of themselves. And this is so important because it frames the entire action as one of protection, not punishment. All right, let's lock this in with another bar question. What are those absolutely essential procedural safeguards that we just talked about? The ones that have to be in place before someone can be committed? The answer covers those 4 key pillars of due process that we saw in Section 2. You need a sufficient petition, a formal order for hearing, proper notice to everybody involved, and you have to bring the person to court. These are not just technicalities. They are fundamental to protecting a person's rights. So, after the hearing, what does a judge actually need to be convinced of before they can order a commitment? Well, Section 3 sets a pretty high bar. First,
There has to be solid proof that the commitment is necessary for either the public's welfare or the person's own good. Second, the court also has to find that the person's family just can't provide the proper care they need. If both of those are met, then the court can order the commitment. And as an extra layer of protection, the court also has to make sure the person's property is safe until a proper guardian can be appointed.
Now, let's shift gears and talk about the end of the process. How does a commitment actually end? And who's representing the government's interests through all of this? Sections 4 and 5 have the answers.
A person isn't just let go when someone feels like it. The process is formal. The same authority that started it all, the Secretary of Health, also has to be the one to file a petition to end it. This happens when a doctor says the person is cured, or at least stable enough to be released without being a danger. And importantly, that petition goes right back to the very same court that ordered the commitment in the first place, ensuring there's judicial oversight from start to finish.
So, who's handling all the legal paperwork and arguments for the Secretary of Health? Well, that's the job of the local public prosecutor, what we used to call the fiscal. They're the ones who draft the petitions for commitment and for discharge, and they represent the government's position in all the court proceedings. Okay, wow, we have covered a lot of ground. So let's take a moment and pull everything back together in our final section, where we'll summarize the key takeaways and core ideas of Rule 101. This summary table really gives us a fantastic bird's eye view, doesn't it? The proceeding is a special one for involuntary confinement. It's filed by the Secretary of Health in the local RTC. The whole purpose is protection, and it's governed by strict due process. The court also protects property, oversees the discharge, and the state is represented by the prosecutor. It's all right there. Now, for one last but really important distinction. How is this different from a regular guardianship under Rule 92? It's pretty simple when you break it down. Rule 101 is laser-focused on one thing: involuntary medical confinement in a hospital. It's about safety. Rule 92 is much broader. That's about appointing a guardian to manage a person's life or their property, and that usually happens outside of a hospital. And look, if you only remember one thing from this entire explainer, please let it be this. Commitment under Rule 101 is a civil action. It is not criminal. It is an act of guardianship, that parens patriae idea, not punishment. The state is simply stepping in to act as a protector for the good of the individual and for society. So, in summary, what this topic really teaches us is that the law demands a strict but compassionate and fair judicial process to protect both the vulnerable and the public when this incredibly serious step of involuntary commitment becomes necessary. It's a powerful example of the law acting as both a shield and a safeguard.